Thank you, Mr. Chairman. That's how it started. Another Senate hearing. What followed was one of the most revealing, unsettling exchanges I've seen on Capitol Hill. Mr. Haas, representing Johnson & Johnson, was in the hot seat. What happened next exposed the thin line between corporate virtue signaling and legal maneuvering. I pressed Mr. Haas. Johnson & Johnson, Procter & Gamble, Apple, and Facebook pledged $50 billion for social change.
You're with Johnson & Johnson, is that right?
Yes, sir.
How is that stakeholder capitalism working out for you?
How is it working for Johnson & Johnson? It's one of the greatest honors of my life.
Okay. I see where you, Johnson & Johnson, has joined with a number of other good American companies, J.P. Morgan. He's not a company. Mr. Colin Kaepernick on his issue of police brutality. Procter & Gamble, Facebook, Apple, y'all pledged $50 billion to, quote, be a force for social change and fight injustice. $50 billion is a lot of money. How is that commitment consistent with what you're asking us to do here today?
Sir, I'm not aware of the particular commitment you're referencing, but I could
It's right
say
here on the
dispositively.
internet. It's got to be right.
I could say dispositively that the consistency is, in the end, to ensure that each and every act that the company takes is consistent with our credo.
Okay.
And our credo puts the public and our patients first.
Right. Let me ask.
Sounds noble, right? But Jan DJ faced tens of billions in talc lawsuits. I asked, how many cases have you lost? 10 out of 42. Some verdicts were in the billions. And when I asked for total damages, silence.
Before I do, I forgot to ask you one question. How many talc cases have you tried to verdict?
There have been 42 cases that have gone to verdict. Of those, we have prevailed in 32.
Okay, so you've lost 10.
Yes.
Okay, and what were the total damages in the 10 that you lost?
The damages ranged dramatically.
Just give me a total.
I don't know the total. I can give you a approximate. The highest one was in the billions.
Okay.
Let's talk about the real scandal, a shady legal move called the Texas two-step. Here's how it works. Corporation A gets hit with lawsuits, creates a shell company, dumps the liabilities, and that shell files for bankruptcy. Legal? Technically. Ethical? You tell me. Courts are split. Some approve it, some reject it. Welcome to the American justice system.
All right, Professor, I don't want to just pick on Johnson & Johnson, but they're the one here. Let me pick on Georgia Pacific, okay? I don't want to pick on anybody. I'm learning on this issue, but let's call them Corporation A gets sued in with respect to mass torts. They spin off the liabilities to a shell corporation, and that shell corporation files Chapter 11 bankruptcy, right?
Sure.
Is that legal under the Bankruptcy Code?
Is that legal? The code does not restrict that necessarily. Courts have found that there are a variety of bases to reject that sort of action. So courts have been pretty active in this space. I should probably, Senator Whitehouse
what's
left.
What's the consensus? I mean, some bankruptcy judges say this is a legitimate use of the Bankruptcy Code, I presume. Other bankruptcy judges say, no, it's not, and it's dismissed. Is that a fair statement?
That is a fair statement. I think that there's some nuance here. If you don't mind, I can flesh it out a little bit.
What's the national consensus on this?
I think the national consensus is that this is a proper action under state law, but to the extent there is some sort of impropriety, bankruptcy court judges are very well positioned to police that, as we've seen in the LTL case. So it's not that Senator Whitehouse pointed out that I was supporting Texas two-step. I'm not supporting Texas two-step. I'm merely providing that.
So
to the extent there is malfeasance,
the
it can be
authority to
addressed.
say this is an abuse of the code, right?
Exactly.
And
courts can address
that. How many have done that?
Well, the most prominent one is LTL. So in the Third Circuit now, there's a very rigorous
test. Is there a
test.
split among the circuits?
There is. So the Fourth Circuit, and we were talking about forum shopping earlier, that would encourage forum shopping, absolutely.
We dug deeper. Bankruptcy judges are the gatekeepers in this dance of evasion. One judge may shut it down, another may rubber stamp it. Legal roulette. Corporations find the softest court and file there. There's no clear national standard. We all knew the truth. I gave them all a chance. The professor called for amending bankruptcy rules, tightening loopholes, protecting victims. But will Congress act? Or will they keep letting corporations dodge accountability? The silence in that room said it all. This wasn't just a hearing. It was a masterclass in double standards. Corporate America pretending to be woke while maneuvering in the shadows to avoid consequences. Next time you see a company post a hashtag or pledge $1 billion for justice, ask if it's real progress or just PR. Until next time, stay informed, stay bold.